Welcome to Rapid Fire Wednesday, Q&A for corporate immigration professionals. I'm Kimberley Robidoux, a partner in San Diego, and I'm joined today, as usual, by Miki Matrician, who's the co-managing partner of our Boston office. How are you today, Miki?
I'm well. Hi, Kim. How are you?
Doing great. All right, so today we're going to discuss updates related to immigration compliance, as well as some information from our benchmarking collective. So, immigration compliance covers several areas, right? Not just the I-9 employment eligibility verification and e-verify processes, but also audits related to H-1B petitions and L-1 petitions. And recently, there have been several agencies involved with compliance actions that have seen a lot of activity affecting employers differently depending on their foreign national population. So, our firm created the Immigration Benchmarking Collective, and from April 9th to May 9th, we surveyed HR, immigration, and global mobility professionals from a range of industries and company sizes in order to help corporate immigration teams benchmark their organization's policies and strategies around navigating US and global compliance. So, this was a direct online survey in which 47 organizations participated. The average number of US foreign nationals employed by the organizations was 436, and the median size was 200 foreign nationals. So, our benchmarking collective was created a little over a year ago, and just recently we made it over 500 members, which is incredible. We're super excited about that. And we would love to have you, global mobility and HR professionals, join the collective if you're interested in meeting with others that are similarly situated, talking through ideas and strategies and our roundtables, and then participating in the surveys in which you'll get first opportunity to see the results. So moving on from the update of our benchmarking collective, we're going to talk about a few topics and results from this latest survey. So Mickey, can you fill us in?
Sure. So, the survey found that a majority of global mobility programs track compliance metrics regularly. So, 72% of programs do that. 19% of programs track somewhat inconsistently. Also, of interest was that overall, teams surveyed reported that they feel fairly confident. So, that's around 60% of the people said their employees and managers understand the basic compliance requirements of work visas. And that's a pretty good number. But there is some room for improvement, and we'd like to provide materials and training to assist individuals working in this field so that they can be more efficient and effective in their roles.
Great. So let's shift over a little bit to the recent activities by the government, the federal government, that is. And what actions are you seeing by the Fraud Detection and National Security Unit, which is affectionately referred to as FDNS?
Yeah, so FDNS officers continue to reach out to companies either in person, but mostly via email for these site visits. And so usually the officer would reach out to the company representative that signed the Form I-129 petition that sponsor the employee for H-1B or individual L-1 classification. And then they schedule a time to meet with the company representative and the foreign national employee. And the purpose of these site visits is really to make sure that the company really did file the petition to sponsor the H1 or L1 worker, and also to make sure that the employee is working in the position as indicated in the approved petition and that they're being paid as indicated in the petition as well. The best way to prepare for these site visits is to stay on top of reviewing the petition materials and gather recent pay statements for the employee, and if there is any discrepancy, to speak with Immigration Counsel.
Great. So we're also expecting additional audits by the US Department of Labor, and that would be audits of the public access files related to H-1B, H-1B1, and E-3 foreign nationals. So, we kind of consider this as some information that HR and global mobility professionals would want to make sure that their public access files are in order and ready to be provided to government official if audited. And these public access files are also available to members of the public if requested. So we want to make sure that everybody is ready for a government visit. So, Mickey, what was another highlight of the survey that is actually related and is talking about the public access file, audit files, as well as the FDNS site visits?
Yeah, so we also asked what processes do you primarily have in place to ensure employees work within their visa conditions. And that's important because if it's not monitored and acted upon properly and timely, it could result in significant compliance issues for the organization, as well as maintenance of status issues for the sponsored foreign national employee. In response to the survey question, over half of employers, so right around 51% of employers, conduct case by case reviews to ensure that compliance steps are taken before job changes or relocation takes effect. And about 23% rely on regular internal audits. 17% of teams don't have a formal process in place, and then only about 6% of teams focus on employee trainings, and 2% focus on manager trainings for visa restrictions. And then, in addition, when asked, how does your company monitor travel and work locations to ensure employees remain compliant with immigration laws? Global Mobility and HR professionals responded that over half of the teams, 53%, rely on employees self reporting to monitor immigration compliance, while 21% don't really actively track it. And then only 13% use travel approval systems, and 13% have automated location tracking.
Yeah, and it was nice to see from the benchmarking survey that about half or 49% of global mobility and HR teams have streamlined or automated solutions, and about 34% rely on manual systems, while 17% actually struggle to stay compliant. And when it comes to auditing immigration records, 30% of teams audit immigration files monthly, 23% quarterly, and 26% annually. And then there's that small percentage of about 17% that only audit when an issue arises. And then there's an additional 4% that don't conduct audits at all, which was really surprising to see that. The benchmarking survey also asked global mobility and HR professionals about my favorite topic, which is I-9 compliance. And specifically, they were asked, how confident are you in your organization's I-9 compliance practices? It was interesting to find out that 40% feel very confident and 38% feel somewhat confident. Meanwhile, 15% of those organizations outsource their I-9 management, and about 6% are not confident in their compliance practices. So, with the increased focus on worksite compliance, it's even more important now for companies to tighten up their I-9 process, including how they utilize E-Verify or whether they should become an E-Verify participant at all.
And Kim, what have you been seeing in the I-9 world that impacts employers with their business operations?
Yeah, well, E-Verify has been doing a little bit of data mining, Miki, and sending emails to employers about EAD card expirations that are pretty much based on revoked parole programs. So employers need to be careful about this, given that USCIS has not provided any information about how quickly employers need to act on the information. Essentially, with individuals having their EADs revoked and with the employers being notified, this could be treated by the government as an employer having actual knowledge that the employee is not authorized to work. So the bottom line is likely the faster to act, the better. And that fast act might actually be, with a global mobility or HR professional reaching out to speak to counsel to talk about how should they address these particular situations, given everything that's going on with litigation, where some programs are terminated and then placed on hold because of the litigation and then move forward again. We've also recently had the termination of TPS for Afghanistan. And depending on litigation, employers should stay informed about the recent actions if they have employees working based on TPS for Afghan nationals, and also for any parole programs that provide work authorization for those individuals. And that Afghan TPS is scheduled to terminate in middle of July. So we'll wait and see, what happens with litigation on that front as well. So I think that's a wrap for today's session. And feel free to tune in for our next session as we continue with updating everyone on what we're seeing in the employment-based immigration world. And so check out our future episodes of Rapid Fire Wednesday. And if you don't already, please follow us on our LinkedIn page for WR Immigration, as well as our individual profiles. And we also transcribe each and every episode and post it to a weekly newsletter that you can subscribe to. And the link to subscribe, if you would like to do so, will be in our video description. So until next week, have a wonderful day, Miki, and a great rest of your week.
Thanks, Kim. You too.